How to monetize intellectual property. Video 3. Proven ways to create and protect intellectual property. Steps 2 through 4. Hello, Joel Douglas here. I am an instructor, guest lecturer with the Shelby Colum Davis Professor of American Business and Economic Enterprise at Trinity College. Thank you for watching this series. This part of the series focuses on expanding your understanding of intellectual property and how to create and protect it. Let's take a deeper dive into proven ways to create IP and protect its value. Okay, let's go on to step 2 in this process. I strongly recommend that you file a provisional patent application prior to conducting a focus group. A provisional application is a patent application filed at the USPTO that establishes an earlier filing date but does not mature into an issued patent unless you file a non-provisional patent application within 1 year that claims the earlier filing date of the provisional patent application. A small entity or individual inventor can file a provisional patent application for approximately $150 filing fee by filing the application online using the USPTO Electronic Filing System, EFS Web. There are a number of companies that can help you file these applications, and you can expect to pay approximately $300 for their services. And I recommend using one of these services if you are a first-time inventor. I also recommend that you participate in the filing and actually do it using the EFS Web system. This initial application should disclose everything that you believe the invention encompasses. Add as much detail as possible because, as I said earlier, it establishes your initial filing date, which is your priority date. The earlier the filing date means that you will have priority over later filed patent applications, which will mean that you will block any later filed application from becoming a patent because you have an earlier filing date which would entitle you to a patent if there is no other prior art filed before your filing date that claims the same invention or that renders your invention obvious. Remember, the USPTO receives over 500,000 utility non-provisional patent applications per year, and looking at the 2015 data, there are more than 2 million international and foreign applications filed per year worldwide. Therefore, it is obvious that an earlier priority date achieved by filing a provisional application is important to prevent an even greater number of possible prior art references to challenge the novelty of your invention. The America Invents Act, commonly referred to as the First Inventor to File law, makes filing date a key factor in determining if the inventor or applicant is eligible for a patent. Therefore, the inventor with the earliest filing date receives precedence and is entitled to a patent before a later filed patent. This earlier priority date is used by the USPTO when they conduct a prior art search to determine if you are eligible for a patent. The earlier the filing date, the better chance you have of being granted a patent. Step 3. Carefully analyze the initial focus group feedback to determine whether your idea is viable and has the potential to be commercially successful. Specifically, compare your estimated product R&D and commercialization costs, including the cost to manufacture, market, and distribute your product with respect to anticipated sales volume and pricing to make sure that you are going to make a profit. Obviously, you want to make more money than it costs you to commercialize the product. Be prepared to repeat the focus group process several times during the product R&D and commercialization phases of your idea continuing to make refinements and corrections regarding features, marketing, distribution. Step 4. I normally recommend entrepreneurs to file a second U.S. provisional patent application, expanding on any ideas that result from the interactions with potential customers, business partners, focus group participants, ongoing development efforts, manufacturing plans, etc. If modifications to the original concept are significant, the second provisional patent application starts the clock for preparing another regular non-provisional patent application. Otherwise, the first provisional patent application establishes the earlier filing date. Whichever provisional patent application you decide to use for your priority date, you must file the U.S. non-provisional patent application no later than 12 months from the filing date of the provisional patent application to maintain your priority rights with the USPTO. The 12-month window allows you time to raise money to support the patent application process and continue refining the product or process designed prior to filing the non-provisional patent application. Remember, you cannot afford to miss the 12-month filing deadline because while the USPTO allows you to revive a provisional patent application up to 14 months from the initial filing date, you can actually lose the ability to patent the idea due to a lapse of a statutory bar such as public use or offer for sale. Thank you for watching, and I look forward to seeing you again for the 4th video entitled Proven Ways to Create and Protect Intellectual Property, Step 5.